Now, the political essence of redistricting and reapportionment has been a reality as long as there have been representative assemblies. Because we like to think that voters get to choose their representatives, but it's also redistricting is where representatives get to choose their voters. And my starting point is the Constitution. Can we have a slide? There we go. Oh, you went one too far. There we go. And can you move the stuff so they can read?
I don't know why it's showing Benita.
Okay, because she's the first person.
Uh,
Okay, what I put on this slide is the articles of the Constitution that are relevant to today's talk. Article 1 allocated members of the House of Representatives to the states according to state populations as determined by a census taken every 10 years. The Constitution also left running elections to the states, but people allowed to vote for members of the state legislature's lower house could vote for members of Congress. And if you, as I've mentioned in prior classes, the House of Representatives, when the original Constitution was written, the only democratically elected federal official were the House members of the House of Representatives. Senators were chosen by state legislatures. They didn't get the popular, that wasn't popular vote until the early 20th century. And the president is selected by members of the Electoral College, who in turn were to be selected by the state legislatures. So there wasn't much love of democracy in those days. Further, Congress can regulate such elections should it choose to do so. And there haven't been too many opportunities where they have. Now, the manner in which the 13 states chose their state and federal legislators varied. Some states elected their representatives by district, and some did it at large. At large voting for, you know, I'm sure you all know what it is. Maybe there's 7 slots and there'd be 15 people for running. You vote for 7 and the 7 with the most votes get the slots. And that's the way many in the early days of our republic, that's the way many representatives were chosen. Some states combined the message. By the end of the 19th century, a majority of states provided that their congressmen would be chosen by voters in single-member congressional districts. But that didn't become a federal rule until 1967. Sometimes you learn these things and you're kind of amazed. But most members of state legislatures run in single-member districts today, but a few, 9 states continue to have 1 or more multi-member state legislative districts. In creating districts for representatives, state legislatures have always considered serving partisan interests. Eldridge Gerry, and I have a thing here to change the slide. No, you'll get him. Eldridge Gerry was one of the original signers of the Declaration of Independence, and he was a member of the 1787 Constitutional Convention. He was governor of Massachusetts from 1810 to 1812. He got the Massachusetts state legislature, oh, there you go, to draw the districts in favor of the Jefferson Democratic Republican Party. The opposition Federalist press was outraged over this attempt to favor one faction by creating weirdly shaped legislative districts. A famous cartoon, and this is the cartoon of this oddly shaped district that looked like a lizard, a salamander, was called a gerrymander, and the name is stuck. And all over the country, state legislatures drew districts that tried to serve partisan interests. And the districts themselves often varied greatly by population. So that's the way things were in the early republic. Now, there's a case that came down in 1849 called Luther versus Borden. It's credited with announcing what's called the political question doctrine. In the early 1840s, and this is a little bit of trivia for you, Rhode Island state government was still based on its colonial charter. All they did when the revolution happened is Rhode Island, which was by the way the last of the original states original 13 colonies to affirm the Constitution. They didn't ratify the Constitution until the federal government threatened to basically close the port of Providence and not allow any goods to enter Rhode Island or accept any Rhode Island exports. Then they said, okay, we're in. It was still based on a colonial charter, which basically provided for a non-elected governor and a very small council to run the state. Now, agitation to replace this with a state constitution reached a fever pitch in the early 1840s. It was called Doer's Rebellion, named after a guy named he spelled his name D-O-E-R-R, who actually led a rebellion. And things got a little violent. Existing state leadership and the elites who were running things were just fine with running the show. And state officials retaliated against this movement's activists. A pro-reform advocate, his name was Martin Luther, are we surprised? I guess there weren't too many Congregationalists there, contended that a search of his house and seizure of documents by a state official named Luther Borden was invalid because the entire state government was illegally composed. This was his argument. He argued that the failure to replace the old royal charter violated the Constitution's Article 4, Section 4, which I'm going to read to you. I had it up on the board a minute ago. It states, let me find it here. Here we go. The United States shall guarantee to every state in this union a republican form of government. So he claimed that the old royal charter of Rhode Island violated this provision. And therefore the search of his house, because it was conducted by an agent of this illegal government, was also illegal. And the case went up to the Supreme Court. Big surprise, he lost. The Supreme Court held that any enforcement of this provision, that is whether a state's government was Republican, rested with Congress as the political power of the national government. This is called the political question doctrine. It's a rule of judicial restraint. The idea is that some political issues are just not justicable. That's a big word, but it means that they're beyond the judicial capacity to resolve. They don't lend themselves to any fixed, relatively definable standards by which to judge. And under separation of powers, resolving political disputes were more properly addressed by the political branches. Congress and state legislatures were more answerable to the people than unelected federal judges. And under the Constitution implies that judges shouldn't decide political issues. Now, this doctrine actually goes back to 1812's Marbury versus Madison case, which is the case where the Supreme Court first announced the doctrine of judicial review, that the Supreme Court had the last word on the law, and it had the last word on what the Constitution means. And if a federal statute or a state statute in McCulloch versus Maryland conflicts with the Constitution, the Supreme Court has the right to say so and declare that that statute violates the Constitution. But when it made that rule, when he was writing the opinion in Marbury versus Madison, he distinguished. He said, this is different than some issues that are purely political, and maybe we shouldn't decide those. And Luther versus Borden took that language, and out of it came this political question doctrine. While the Supreme Court has the last word on what the Constitution means, the political question doctrine says, not always. This doctrine is critically important in a lot of cases, especially in the cases involving redistricting and gerrymandering, as we're going to see. And Luther versus Borden, this doctrine makes a lot of sense considering the vagueness of the language in Article 4, Section 4. What is a Republican form of government? Does the definition vary depending on place, depending on time, depending on political culture? There's no standard. And how is an unelected judge to say this is or is not Republican enough? That's what the essence of the political question doctrine goes to. And you'll see this will come up in the issue of gerrymandering. And it creates a conundrum. Really, it does. Okay. What about redistricting and apportionment? Those issues related to redistricting and apportionment didn't reach the Supreme Court until 1946. No case involved it reached the Supreme Court until then. Now, Illinois had not redrawn its congressional districts since the 1900 census. And by the 1940s, urban populations, especially in Chicago, were grossly underrepresented. A number of urban voters filed suit, and they claimed that the existing districts were unconstitutional and that elections should be postponed until the state redrew those districts and made them more fair. They made 2 points. First, redistricting was necessary to assure that the state had a Republican form of government. And second, such malapportioned districts so debased the value of their votes so as to constitute a violation of equal protection. That not redistricting was a state action, and state actions that deny citizens equal protection of the law are unconstitutional. That's the 14th Amendment. That's what the Equal Protection Clause means. Now, they lost. The case is Coldgrove versus Green, 1946. The Supreme Court divided 5-4, applied the political question doctrine because redistricting was an issue, quote, of a particular political nature not appropriate for judicial determination, close quote. Justice Hugo Black dissented and argued that the state's refusal to reapportion its congressional district to make them relatively equal in population was a state action that denied urban voters equal protection under the 14th Amendment. But the majority opinion written by Felix Frankfurter did not directly refute the equal protection argument. Rather, he said that because the Constitution leaves redistricting up to state legislatures, how they chose to do so was purely political, and the judiciary should not interfere. Now, I wanted to, what divides a conservative versus a liberal judge? Because we use those terms a lot. And I think it's important to try and pin them down. And in the context of rights of individuals in our society, liberal judges generally prioritize protecting rights, especially those of the people without voices and minorities, even unpopular minorities, be they racial immigrants, politically radical, disabled, the downtrodden, homeless, criminal defendants. The Bill of Rights and the guarantees of due process and equal protection are there for a reason, and the courts should use them. On the other hand, conservative justices favor a more limited role for federal judges who are unelected and serve for life. They believe that in our democracy, the democratically responsive political arms of our government should make, and not unelected federal judges, should speak for the majority that elected them. And because the political branches, are answerable or more answerable to the electorate than judges, and therefore judges should not make major decisions that set or ban social policies, especially those that may be new, unpopular, or which a significant segment of our society are contrary to the express will of the people acting for their state legislatures. And this is why conservative judges objected to the idea of gay marriage being a protected right in the Constitution. If this is to happen, it should happen through democratically elected bodies, not unelected federal judges. That's the idea. That's really where the division is between conservative and liberal judges. But there is a third category, and I call them reactionary. They will use any argument to decide a case that produces their desired result. They often invoke the idea of originalism. the intent and understanding of those who drafted and approved the constitutional provisions, or which were understood by society at that time to support their views. Now, I think that's bunk and hokum. And next year, I think I'm going to devote a class just to the idea of originalism, because I could talk about it for hours. I mean, it's there. Now, during the 1960s, the Warren Court, which was dominated by what we would call liberal justices, again addressed political boundaries as whether they were state action in the context of constitutional rights. In 1960, a case came called Gomillan versus Lightfoot. You don't need to remember that name. It's not going to be on the exam. The Alabama legislature had redrawn the boundaries of the city of Tuskegee so that most Black households were outside the city limits. And they did so without affecting any white voters. Now, the Supreme Court held that Alabama violated the 15th Amendment by this action by preventing Blacks from voting in city elections. Justice Frankfurter wrote the majority opinion, and he distinguished the Cold Grove case because it did not approve affirmative state action to discriminate on the basis of race. Now, his majority opinion in Gomillan versus Lightfoot is an example of what lawyers are trained to do. If you want to avoid following a precedent, you distinguish it on the facts. You say the facts of your case are different than the facts of that case. Therefore, the rule in that case doesn't apply to this case. It's not always intellectually honest. And I would argue with Justice Frankfurter that intentionally ignoring massive demographic changes and failing to redistrict for decades to allow rural voters to enjoy greater power than urban voters is as much a state action as intentionally redrawing districts to exclude voters of a particular race. Now, in 1962, the districting came again to the Supreme Court. Tennessee, just like Illinois, had not redrawn its districts since the 1900 census. And a lot of states were in this position. In Baker versus Carr, the Supreme Court held that plaintiffs who alleged that this was state action should not have had their case dismissed at the outset when they claimed that equal protection was violated. And it's interesting to note here that the plaintiffs were smart enough not to invoke the guarantee of a Republican form of government. They said it's strictly an equal protection issue. Our vote is being debased by this gross inequity of population size to the extent that our vote is meaningless. And to make our vote meaningless is just as bad as saying, I can't cast it in the first place. That was their argument. And the Supreme Court said, you're right. The district court should not have dismissed your complaint. And they remanded the case back to the district court. They didn't tell the district court what they ought to do. Now, the majority, 5-4, said the political question didn't bar their claim, which was based on equal protection. The Constitution leaves elections up to the states, but how they do it must comply with constitutional standards. That's what the court case said. Grossly unequal weighting of plaintiffs' votes, that is, debasing the value of their votes, was a form of, quote, invidious discrimination, close quote. It's not mine. The drugs are at the airport. Right, okay. The right to have one's votes counted and matter to the same extent as another's vote, quote, is protected equally with the right to put the vote in the ballot box, close quote. And courts have a duty to protect and enforce the requirements of due process and equal protection. Now, Justice Felix Frankfurter dissented adamantly, and this was his last dissent. He retired at the end of the 1962 term. But Frankfurter is really an enigma. He was born in Austria in 1894. Long time ago. He's older even than we are. He came to the United States at the age of 12. He was a bright kid, so bright that he got into Harvard Law School and graduated at the top of his class. In World War I, he was hired as a staff lawyer in the Department of War. And while he was there, he had met Franklin Roosevelt, who was Assistant Secretary of the Navy. They were roughly the same age. And they established, the relationship started there. When it deepened when Roosevelt became elected governor of New York. And when Roosevelt was elected president, Frankfurter became a member of what they called the kitchen cabinet. He was an informal, non-official advisor to Roosevelt. And basically what Frankfurter did was funnel the really bright kids from Harvard who had graduated or were in Harvard Law School to work in the New Deal. And Frankfurter was an avid New Dealer. And Roosevelt put him on the court in 1939. But Frankfurter believed strongly in the power of democratically elected governments, and judges were not elected. And he believed strongly in judicial restraint. And in Baker versus Carr, he dissented. If the majority's holding, he said, was blatant judicial activism, it threatened the Supreme Court's standing and public confidence. The political question doctrine was an important rule. In our democratic society, political issues relating to apportionment and redistricting should be left to the democratically elected state legislatures. Frankfurter noted that disparate population of congressional districts occurred in the majority of states and had existed for decades. Quote, plaintiffs have an agreed personal interest, but their complaint was of that class of political controversy which is unfit for federal judicial action, close quote. And Frankfurter adamantly supported the New Deal, and he adamantly opposed all the Supreme Court cases that struck down New Deal provisions as being judicial activism. Hey, this was passed by Congress. The people's representatives made this the law. Who are you to say it shouldn't be the law? And that was his point of view. So when it came to the Warren Court, all of a sudden, Frankfurter is now a dissenter because the Warren Court is using activism, liberal activism, to take the idea of equal protection and due process and say, hey, this applies to stuff that elected legislatures are doing, and it's wrong. They shouldn't be doing this. And there's a real, it's not an easy question. There are two sides, believe it or not. It's not a false equivalency. Now, Frankfurter, as I said, retired at the end of the 1962 term. He was 80 years old. Quite a few states had been neglected to reapportion, as I mentioned, since 1900, mostly in the South. And two cases decided in 1964 gave the Supreme Court's solid liberal majority the opportunity to set a clear, easily understood rule. As to congressional districts, a case called Westbury versus Sanders, held by 6-2, that the provision in Article 1, Section 2, that members of the House were to be chosen by the people of the several states, meant that, quote, as nearly as practicable, one man's vote in congressional elections is worth as much as another's, close quote. And equal protection required that this be so. One dissent argued that if a national rule was necessary, it was a matter for Congress to decide, not a group of appointed judges. Now, the same day that that case was announced, another case was announced, Reynolds versus Sims. This one was 8-1. And it involves state legislative districts. And the court held that equal protection required that state legislatures, both houses of state legislatures, must be apportioned based on population. That even a state senate, which might be where they did one member of the state senate per county, as opposed to based on population, violated equal protection. That it was state action that violated equal protection to have any state legislators elected other than by popular vote through proportional districting. And this is the case that the term one man, one vote appears. Debasing the value of a citizen's vote was tantamount to denying the right to vote altogether, and the political question doctrine did not prevent the judiciary from protecting that basic right. Now, there was some grumbling, but the country seemed to understand and accept it. The idea of one man, one vote is simple, it's fair, and it's in keeping with democratic ideals. So there wasn't any really, there was some very temporary pushback at the beginning of the 1960s. But after that, the states got in line, and they didn't try to do this or evade it. They said, okay, that's fair, we'll go along with it. And that became the rule very quickly in the country. There wasn't a lot of pushback on it. Now, subsequent cases held that mechanical exactness was not required. But they did say that significant variances between districts was, quote, highly suspect, as was any failure to reapportion in response to the federal census that's taken every 10 years. So that really became the rule. But in 1973, a case called White versus Weiser held that arranging districts to serve political ends was okay. Quote, politics and political considerations are inseparable from districting and apportionment, close quote. The Supreme Court, quote, has no constitutional warrant to invalidate a state plan otherwise within tolerable population limits because the plan minimizes or eliminates the political strength of any party, close quote. The Supreme Court was not ready to tank the political question doctrine in 1973. Now, up to this point, all the cases did was count noses. And equal protection required that congressional districts and all state legislative districts have the same number of noses. But should it matter whose noses are counted? Can arranging how people are allocated between districts debase the value of a person's vote to the extent that that person is denied equal protection? Now, that's the issue that the Voting Rights Act would force the Supreme Court to confront in the context of race. Because the political question doctrine doesn't apply when race applies. Why? Because the Constitution says so, and because Congress said so in the Voting Rights Act. The Voting Rights Act said you can't, the voting decisions can't be based on race. So that's the question that I'm going to go over after the break. I've gone for an hour, for about half an hour. Are there any questions? Yes.
Did the one man, one vote change the California Senate
Yes, it did.
at that point?
At that time.
What year was that again?
Reynolds versus Sim was 1964. And so, yeah, I have a vague recollection. I started law school in 1965. I graduated from college in 1964, immediately started law school. And I was a babe out of the woods. I had about as much, I had the Vietnam War to deal with, civil rights in the South to deal with. Baker versus Carr didn't even kind of hit my conscience, especially since I had just started to vote, because it was 21. You had to vote at 21 and 18 didn't come in until after the Vietnam War.
Oh, how come that didn't affect the US Senate?
Because the Constitution says specifically that each state is entitled to 2 senators, and in order to change that, you got to get every state to agree. Period. End of discussion. And when in Reynolds versus Sim, the argument against Reynolds versus Sim included an argument: why should both houses of the state legislature be subject to this? After all, we're just following the model of Congress. And the answer to that was that Congress isn't bound by the equal protection rule when it comes to senators, because the Constitution specifically states there'll be 2 senators for every state. And they said, your argument as far as the states are concerned, they don't get the same pass, the free pass that the Senate does. Does that answer your question? Okay, now you know. Yes. Yeah.
In the chat, people are asking that you can repeat the question.
Oh, okay. The last question was why, if the Senate is allocated on a per state basis, why can't a state allocate its upper house of a state legislature on a per county basis? And the answer was that equal protection doesn't apply when it comes to the Senate because the Senate's in the Constitution. Okay, next question.
Has the Electoral College ever been challenged at the Supreme Court?
Has the Electoral College ever been challenged at the Supreme Court level? Short answer, no. For those of you who take the LA Times, I don't know if you do, but I do. And there's an article by Joseph Ellis in yesterday's edition on why we have the Electoral College and what's wrong with it. And if you have access to it, I'll be, or if you email me, I'll be happy to email you a copy of this article. It's pretty short. Ellis, who is a Pulitzer Prize winning historian, says that the reason the Electoral College is in the Constitution is because the framers of the Constitution did not believe in democracy. They felt that, the mob rule. And the idea was the people's will should be filtered through people who know better. And this filtering would be done through the Electoral College. And the Electoral College would be fair in that it would basically give each state the same number of votes that they had in the federal Congress, which means one vote per congressman and one vote per senator, which skews the Electoral College because the Senate is not democratically, or it's not population based, in favor of the smaller states. And then the question is, can it be changed? It would take a constitutional amendment to change it. How do you do a constitutional amendment? Either 2/3 of each house of Congress propose it and 3/4 of state legislatures approve it, or 2/3 of the state legislatures call for a convention. The convention proposes changes, and 3/4 of each state of the state legislatures approve each one of those changes. So the idea of amending the state constitution is very difficult. And last class, you'll recall, I put up a map that showed the different states in their reference to population. And over half the states have less than 2 million population. I think it's 13 and 8, pardon me. 23 of the states have less than 23 of the 50 states have less than 2 million population, which certainly is enough states to kill any amendment that they think weakens their power. Has anyone ever who has power voluntarily given it up, other than maybe Cincinnatus and George Washington? It just doesn't happen.
But that's where the power of the court comes in.
But the power of the court does not have the power to change the Constitution. It has the power to interpret the Constitution, but it doesn't have the power to change it. And to get rid of the Electoral College, you got to change the Constitution. Does that answer your question? I know it's not the answer you're looking for.
So I don't care anymore.
Right. I'm how old?
80.
I'm 82, so I agree with you. Yes.
I'm curious about the concept of balance of power, since it applies to
Balance of power.
Does that come out of the political questions doctrine, or does it ideologically predate that?
In what context are you thinking of balance of power?
The question of whether the court can intervene in that there's a limited sphere of the court intervening.
Okay. What you say is balance of power, I think you mean separation of powers, because there's a difference. Balance of powers implies that powers are balanced against each other, so that no one power can overwhelm another power. Separation of powers means allocating powers to different branches of government to separate those powers and prevent the same thing. The whole idea of separation of powers is to prevent one section of government from becoming too powerful. And so this goes back to the revolution, the political theory at the time of the American Revolution. At that time, the model was the British model, which compared to all the other European states was considered the best. And it was based on this idea of balance of power, that all powers were represented equally in government. You had the king, hereditary, you had the hereditary aristocracy, and you had the common people. And that these three things balanced each other to prevent anyone from becoming overly powerful. But we got away with the monarchy, and we got away with hereditary rights. So what are you going to replace this concept of balance of power with? And with separation of power between different political institutions. That was the theoretical change that our Constitution is based on. Does that answer your question? Yes, sir.
Regarding presidential executive direct orders being overturned by the Supreme Court, I understand that has not, it's not mentioned in the Constitution. Neither is the issuance of executive orders by the president.
You're right. They're not, the question relates to executive orders and to what they're not mentioned in the Constitution. So how do they fit in? Well, the answer is the executive under Article 3 is given certain powers. Among those are, he's commander-in-chief of the armed forces. He is supposed to, I'll read it to you. The executive power shall be vested in the President of the United States. He shall hold his office during the term of 4 years, and together with the vice president be chosen as follows, blah, blah, blah. And that's the Electoral College. And then it says the president shall at all state, okay, then it says powers. He shall, section 2, the president shall be commander-in-chief of the Army and Navy, of the militia of the several states, when they're called into actual service of the U.S. He may require the opinion in writing of the principal officer in each of the executive departments on any subject relating to the duties of their offices, shall have the power to grant reprieves and pardons, except in cases. He shall have power with the advice and consent of the Senate to do treaties, et cetera, et cetera. And he shall power to fill vacancies, and he shall see that the laws be faithfully executed. He is in fact in charge of the executive branch of government. Now, an executive order is an order to a branch of government to do something. If it violates the Constitution, the Supreme Court, like it can with the law, judicial review extends to executive orders. If he's directing a federal officer to do something the Constitution does not allow, the Supreme Court under judicial review can say so. And the source of his power in executive orders is his power to administer the executive branch, which includes all the agencies under the executive branch. That's where the power for executive orders comes from, and the ability of the court to pass on them comes from judicial review. The Supreme Court is the last word on whether or not some action of another branch of government conflicts with the Constitution. Ron, yes.
So if the head of the executive, the president, says that he wants to do something that, say, like the chief of naval operations, you know, the four parties.
The Joint Chiefs of Staff.
Thank you. Joint Chiefs of Staff think it's not a good idea. They go to the Supreme Court and say, we really don't want to do what is being said here. Can the Supreme Court actually stop it?
Okay, the question is, can the Supreme Court overturn an executive order? Because even though it might be within the president's power, they don't think it's a good idea. Is that a fair way of rephrasing your question, Ron?
That's correct.
The answer, short answer, no.
That's why I'm worried.
Yeah, you know, we're going to get to that because yes, the Supreme Court should not, if it's within the president's power, it's not for the Supreme Court to say it's not a good idea, because under separation of powers, That job is given to the president under the Constitution. That's why I think the Supreme Court made a big mistake. And I'm gonna get to that after the break, when it threw out the pre-clearance requirement in the Voting Rights Act. Because Congress had passed that almost unanimously. And there was a record in earlier Congress as to why it was necessary. And the Supreme Court said, well, we don't think it's necessary anymore. And because this is an extraordinary act, it's beyond, federal government shouldn't require a state to get pre-clearance approval before a state law can go into effect. We're gonna say, no, you can't do this anymore. And so it's a problem, and it's an area that I'm going to talk about after the break. Any other questions? Yes.
When Biden tried to get the student loans forgiven, and the Supreme Court ruled on that, that was not an executive order then?
That was an executive order, and the Supreme Court ruled on it, said that the executive order went too far because the student loan provisions were set up by Congress. And by forgiving the loans, the president was in effect changing the rules that Congress had set up for repayment of student loans. And the president didn't have the power to do that. Also, there's a provision in the Constitution, and it's not one that most people think about, that states in Article I gotta find out where it is. I can't remember if it's in Article 4 or 6. It's the one that says no state shall. I should know this by heart. Yeah, I know. Well, basically it says, here it is. No state shall have the power to alter to abrogate the right of contract. Let me find it right here. It's at the end of a long sentence, so I got to find out where it is. Here it is. All debts, contracted, and engagements entered into shall be valid against under this Constitution. Blah blah blah. And no state shall have the power to abrogate the right of contract. It's where it is, and for some reason I'm not finding it because I've got new glasses. But that's another reason why Biden could not, by executive order, forgive student loans, because a student loan is a contract. And there's a provision in the Constitution that deprives the government of the right to abrogate rights that exist under a contract. And the reason this was there was goes back to the economic turmoil that happened between the end of the Revolutionary War and the time of the adoption of the Constitution. And a number of states had written laws that basically forgave state debts because farmers there was a gross, what had happened is that most states financed the Revolutionary War by issuing IOUs. And they would, so when the state requisitioned goods from a farmer to feed the soldiers, it would give them an IOU. And soldiers were paid with these IOUs. Now people needed money, so they sold their IOUs at a discount to speculators who bought them. So it turned out that by the late 1780s, by 1786, 90% of the state debt of Massachusetts was held by 35 people. Because they bought up all the IOUs. And then Massachusetts passed a law that says we're not gonna pay those back. And that, and then that law was overturned. And then another law was passed saying, yes, we are gonna pay it back. And farmers who didn't like it, who got screwed, who said, why should our taxes now pay back these things at 100 cents on the dollar, actually revolted. And there was a thing called Shays Rebellion in Massachusetts in 1886. And that's what led to the Constitution. And a provision in the Constitution says, no state shall impair the obligation of contracts. And so that's also a problem with the loan forgiveness program. Okay, let's take a short break, 5 minutes, and then we'll resume.
Maybe we're taking this off on a tangent, but what about just proportional?
I'm gonna get to that, because the Supreme Court, actually, the question was, what about proportional representation? And that was an issue that someone had made last time, who has a European heritage, which is the practice in Europe. And there's a case that I'm gonna talk to in this half, where the Supreme Court expressly responded to that issue. So let's wait. Okay, let me continue where we were. Where we broke off was with the redistricting. And the fact that we're at the idea of doesn't matter whose no's were counted. And when it came, the Voting Rights Act made, yes, it does matter whose no's is counted, especially where there's noses, happen to be noses of a minority. And that takes us to the 1965 Voting Rights Act. Now, last year, I did a whole class on the Voting Rights Act, but I think it's necessary to review some of that because without doing that, if you weren't there, you don't remember it because it was a long time ago, and I don't remember anything, what I had for dinner yesterday, let alone what I said a year ago. Let's review the Voting Rights Act. It was passed in response to Southern resistance to the Civil Rights Movement. I remember Senate GOP leader Everett Dirksen saying, there's nothing as powerful as an idea whose time has come. And I also remember Lyndon Johnson ending a speech plugging the Voting Rights Act to a special session of Congress when he said, and we shall overcome. The Voting Rights Act had two main provisions. One, Section 2, outlawed any law, practice, or procedure that had a discriminatory purpose or effect, such as practices designed to prevent Blacks from voting or to minimize the impact of their votes. That's Section 2 of the Voting Rights Act. The other, Section 5, required prior approval, that is pre-clearance by the Department of Justice, which acted through its Civil Rights Division, in those specified states and localities that had a history of racial discrimination voting laws and practices, and that pre-clearance had to be granted before any new law could take effect. Now, when Congress originally passed the Voting Rights Act, the pre-clearance requirement was to expire in 5 years. Congress repeatedly extended the requirement in 2006, in 2001, and again in 2006. And in 2006, it was extended for 35 years. And the vote was 99-1 in the Senate, and it was virtually unanimous in the House. And at that time, pre-clearance in 2006 applied to 9 southern states and specific counties and districts and 13 others. Now, back in 1966, in a case called South Carolina versus Katzenbach, who was then the Attorney General, the Supreme Court upheld the pre-clearance provisions 8-1. Only Justice Black felt the Constitution did not allow Congress to ever require states to get federal approval before a state law that was ostensibly within their authority could take effect. But 8 justices said, yeah, in this case, it's okay. Chief Justices Warren, the remainder of the Voting Rights Act was upheld 9-0 to Section 2. Chief Justice Warren's opinion held that because the 14th and 15th Amendments grant Congress the power to enforce them, The exercise of that power will be upheld if Congress used, quote, any rational means, close quote, to address race-based voter discrimination. The Supreme Court specifically says that the history of discrimination that was laid out in the congressional record amply justified the pre-clearance provisions. Now, every 10 years following the census, one was in 1970, 1980, 1990, 2000, 2010, next one again, 2020, at least up through 2010, the Civil Rights Division of the Department of Justice had to deal with pre-clearance requests because every 10 years the state had to redistrict, and districting is within the Voting Rights Act. They have to get the Department of Justice approval to approve their districts. Now, historically, part of the purpose of the Voting Rights Act was to assure that non-whites votes would not be so diluted that to prevent minorities from electing representatives of their choice. Historically, Southern maps had so diffused the minority voters who were within those states as to make them simply irrelevant. Or if there were simply too many to do that, they would try and pack them all in one district. With as many black voters as possible to limit the number of districts where their votes mattered. So since the 1940s, okay, so that was the Voting Rights Act. Now, since the 1940s, the Supreme Court had held that racial considerations were disfavored. They adopted the strict scrutiny rule slide. Here it is. It's really an important rule. Any state action predicated upon or involving racial considerations was unconstitutional unless, one, the action had to serve a compelling state interest. Two, that there was no other way to serve that interest other than by considering race. And three, that the action must be narrowly tailored so as to impact innocent members of the majority as little as possible. Those were the three requirements that if you're going to consider race at all, if race has to be considered, this is the test it has to follow. Because in this country, we don't want decisions based on race. Why? Because more often than not, they discriminate against minorities. That's the rule behind the strict scrutiny test. And the test is important. It's at the heart of all the cases on race and college admissions that we talked about last year. And under the Voting Rights Act, navigating redistricting ended up inundating the federal courts with whites and blacks alike promoting objecting the plans. And North Carolina is a case in point. I'm going to show this map shows 4 North Carolina cases before. And 4 times the Supreme Court had to decide cases involving North Carolina's maps. And almost all of them involve the same district, District 12, which starts out, it's that little thing that starts out at the north end of the state, comes all the way down to the south end of the state. And it's in one form or another, there's a District 12 in every one of these maps that is a problem. Following the 1980 census, the Department of Justice Civil Rights Division conditioned pre-clearance for North Carolina on creating what's called 2 majority minority districts. That's a district where a minority population was in the majority, to ensure that black voters would have the ability to elect representatives of their choice. And the North Carolina legislature tried to comply. Now, when they did, white voters in District 12 said that, wait a minute, this map is based on race and we're being discriminated against. 4 times proposed districting plans ends up in the Supreme Court, and 4 times the majority of Supreme Court justices said that they got it wrong. I'm going to go through these cases just because it gets very confusing. And you'll see, by the way, yes, sir. I got quite Ron in the back.
Yeah, go back a slide. I'm very confused by C.
Is the action so narrowly tailored that it impacts innocent members of the majority as little as possible? What don't you understand? Where are you confused?
I understand the words, but it seems like, I mean, if the vote is counted by whoever is there, I don't understand how, oh, I'm sorry, this is not good for the majority. Let's change this.
Because it's weighing the balances. If race is necessary to create a minority district, it goes without question that some white voters are going to be disadvantaged. How seriously are they, and how many of them are being disadvantaged?
That seems like.
It's a moving target. Yes, it is, Ron. There's no simple answer. It's a moving target.
That sounds very unfair.
Well, fairness is itself a moving target. And what happens, the Supreme Court's trying, that's why I said at the beginning, people look for tests. They want easy answers. So they create tests to try and give them easy solutions. But it isn't always that easy. And sometimes it produces bad results. And I'm not saying that the strict scrutiny test is good, but what I am saying, will say, is that the Supreme Court used it in many cases to the advantage of minorities. It's also been used to disadvantage minorities, all based on that squiggly room where how much is too much, how fair is fair. And I can't get any more than that. I mean, I can't give you a better answer than that. I mean, I used to like the answer, you know, Mom, can I do this? It depends. Okay. The first time this case came about, I'm looking at the upper left-hand side, was in Shaw versus Reno. White voters had complained saying that the maps passed, dismissed, the district court dismissed the white voters' complaint saying that the maps passed the strict scrutiny test. Yeah, some of them were inconvenienced, but not too many. And besides, it was absolutely necessary. White voters, Supreme Court said, no, he didn't pass the test, threw it out. So they still objected, and in Shaw versus Hunt, the district court found that the maps passed the test again, and the Supreme Court said, no, they weren't narrowly tailored. And the white voters won again. After the 1990 census, the map was redone, changed, and drafters testified that their aims were mostly political, although race had to have been considered. White voters objected, and I can't tell who's doing, but in Hunt versus Cromartie, which is the upper right-hand side, the district court granted summary judgment disapproving the maps, and the Supreme Court said, no, it's not a proper case for summary judgment. They should have had their day in court, and you should have taken evidence. Summary judgment said, based on pleadings and affidavits, there's no triable issue of fact. We don't need to have a trial. The case is over. And if summary judgment is reversed, all it means is, okay, you get to have a trial. So they had a trial. And this time after trial, a different district court judge approves the maps. And the Supreme Court says, no, your finding was clearly erroneous. The district court should have found that the revised map was based predominantly on race, and it was not properly done. Then in 2013, in Shelby County versus Holder, the Supreme Court voided the pre-clearance requirement as unconstitutional. And I talked about this just before the break. Chief Justice Roberts, joined by Thomas, Scalia, Kennedy, and Alito, held that pre-clearance was an, quote, uncommon exercise of congressional power. That was the same term that Justice Black had used in his lone dissent back when, in the Katzenbach case, when the Voting Rights Act was affirmed. And Justice Roberts said it might have been justified in 1965, but it wasn't justified 42 years later, in 2013. The majority noted that in 2013, Black voters were registered in roughly equal proportion to white voters. Minority candidates were elected in record numbers, even a Black president, he pointed out. And that blatant discriminatory practices were rare And Congress's 2006 extension of preclearance was not supported by evidence of current pervasive discrimination as had been present in 1965. The case gutted the Voting Rights Act of what had been its most effective tool, preclearance. Now, part of the reason the court did so is you could make an argument that the Justice Department had overstepped its bounds in granting plea clearance. Instead of asking what is the minimum you need to do to satisfy the Voting Rights Act, the Civil Rights Division tried to push the envelope and to increase the voting power of minorities, to use the Voting Rights Act to increase the voting power of minorities, to make the minorities really the dominant elective power within some of the states. And I think that that overreaching, which has been mentioned in some of the opinions in these cases, was one of the reasons why the court threw out preclearance. Sometimes what's actually done on the ground can be the worst enemy of what's right. And that might have been what happened here.
That apply only to North Carolina?
No, when they threw out the preclearance requirement, it threw it out, period, everywhere. And by throwing it out, the preclearance had been the most effective tool to prevent states from inventing new techniques to discriminate against so-called undesirable voters. That is, voters who habitually didn't support the existing power structures. Now, the problem is this. It still had Section 2, but civil rights violations, voting rights violation litigation is really expensive. The only way it can be brought is if you get some non-governmental, non-GO, some some institution to back your position and to put up the lawyers and the monies and do all of the work that's necessary to prove the case. Because it takes a huge amount of money to prosecute one of these cases. You have to have the manpower to go through all the data that was considered when drawing the maps and all the data that they could have considered but didn't. And you have to go through and run permutations of what other possibilities are there and how would these possibilities impact minority voters in all these districts. In other words, you got to have very expensive and complex computer programs to run all these projections. This costs a lot of money. And you've got to have, both at the trial level and appellate level, you got to have a lot of lawyering. And one of the things I remembered when I practiced law was that I could not afford me. You're talking about beaucoup bucks. And so the average, how much ability does the average voter have to bring a lawsuit challenging a vote as applied to him? Not a lot. And that's really the problem when you gutted preclearance. Now, at the same time that the preclearance decision came out, another case was decided almost the same day. It was called National Federation of Independent Businesses versus Sibelius. Any of you remember the name of that case? In that case, Congress, a lot of states had filed a lawsuit, and a lot of groups, including this National Federation of Independent Businesses, had filed a lawsuit to invalidate the Voting Rights Act. Not the Voting Rights Act, the Affordable Care Act, Obamacare, the ACA. And the Supreme Court in this case upheld it. And Roberts wrote the majority opinion. It was 5-4. The other conservatives didn't go along with him, but he allied himself with the 4 liberals at that time and said, yeah, I don't agree with this. I think it's a terrible law, but it's within Congress's power, and therefore the law is valid. Now, how in the hell can he say on one day that the Voting Rights Act is, I don't like it, but it's lawful, and the Affordable Care Act, but then on the, say that the Voting Rights Act preclearance isn't? Now he distinguishes them on the facts. I call that result-oriented jurisprudence. It's not. It's obviously political, and it's using a doctrine to bring about the result you want. But that's where that's where this, I'm not saying it's intellectually dishonest. The system is set up for him to do it. But it's applying different rules differently based on political considerations. And that happens. So let's go back to North Carolina. In response to the 2010 census, the GOP-controlled legislature redrew the maps. Now, they had to add about 100,000 new voters to District 1 to meet the one man, one vote rule. So what they did was pack as many voters as possible into District 1 and added a slew more Black voters into District 12. And they announced the plan and Black voters objected. Now, the legislature, the proponents of the plan, argued that they did so in order to comply with the Voting Rights Act, to ensure that both districts would elect Black-supported representatives. But the true purpose was to pack these two districts with as many Black voters as possible to dilute their strength in other districts. The district court ruled for the objectors, and surprise of all, the Supreme Court agreed. And the objectors were Black. The case is Cooper versus Harris, and by 5-4, it held that the district court's factual findings were predominated, and it wasn't necessary to add Black voters to Districts 1 and District 12 to comply with the Voting Rights Act, because those districts had already elected Black representatives. Claiborne was represented District 1, and I forgot the name of the guy who represented District 12. Hard to believe Thomas joined in along with Kagan, Ginsburg, and Breyer and Sotomayor, and held simply that the district court's findings were adequate. They supported the decision, and it wasn't for the Supreme Court to turn it down. My God, judicial restraint actually brought about a right result. So the GOP legislature tries again. And this time they created 3 safely Democratic districts, while the other 10 were safely or leaning Republican. The Republican planners had testified it wasn't possible to limit Democrats to 2 districts without putting more Republican districts at risk. Democratic organizations sued, not that the revised plan violated the Voting Rights Act, but because partisan gerrymandering itself was unconstitutional. Good for them. They claimed that gerrymandered plan violated Article 1, which allegedly implies that elections would be fair. It violates the First Amendment's free speech protection in that it discriminates against Democratic voters based on their political views. And it violates equal protection by debasing the value of Democratic voters' vote in Republican districts. Now, in Maryland, a Democratic legislature had done the exact same thing. They voted all the Republicans in 1 or 2 districts, so the others would all be Democratic. And Republicans sued on the same exact grounds in Maryland federal court. And guess what? In both Maryland district court in North Carolina and in district court in Maryland, the district court found that the gerrymandering was unconstitutional. So if the Republicans did it, it was wrong, and if the Democrats did it, it was wrong. And the case goes up to the Supreme Court. And the case is called Rucho versus Common Cause in 2019. The majority was Roberts, Thomas, Alito, Gorsuch, and Kavanaugh. The usual, I think that's, in Casablanca, there's that wonderful quote, round up the usual suspects. The usual suspects. They invoked the political question doctrine. They invoked the political question doctrine, and they tossed out both cases. They acknowledged that partisan gerrymandering does dilute votes of disadvantaged voters based on their political persuasions. But, tough, not every wrong has a judicial remedy. The majority held that claims against partisan gerrymandering fell properly under Article 4, Section 4, the guarantee of a Republican form of government. It didn't violate the First Amendment's guarantee of freedom of speech because gerrymandering didn't censor expression. You weren't being censored. And there's nothing about free speech, the guarantee of free speech, that says that one person's speech would be equally effective as another's. Simple math, counting noses, as Baker versus Carr and Reynolds versus Sim held, was different. Counting noses provides an easily enforceable bright line rule that addresses population inequality. One man, one vote. Simple. Don't have to go any further. Racial gerrymandering can and must be addressed by the courts. We got no choice on this. We don't like it because the Voting Rights Act itself and the 14th Amendment ban certain state actions, and the Supreme Court has to decide if the Voting Rights Act is constitutional, et cetera, or if it's being properly applied where it is constitutional. But purely partisan districting is different. That's what he alleges. The Constitution, that is the framers, left apportionment and districting up to political institutions. Namely, they leave it up to state legislatures. This implies that the Constitution drafters understood that districting is a political process. This is where the originalism comes in. Thus, it's inevitable that partisans' interest will impact districting decisions. And the opinion states that it's impossible for courts to decide when there is too much partisanship. Any standard for judges to resolve equal protection claims arising from redistricting must be grounded in, quote, a limited and precise rationale and be clear, manageable, and politically neutral, close quote. No such standard exists without specifically excluding partisan considerations altogether. And that's neither possible nor constitutional for judges to do so. Judges don't have the power to tell states they must disregard partisan issues. The Constitution vests that process in political institutions such as state legislatures, which, and believe it or not, Congress might have the power to do that. Possibly Congress might have the power to instruct states that they cannot consider political partisanship affecting their districting decisions. How many people, raise your hands, think it's ever likely that Congress will actually do that? You think Mark thinks, you're such an optimist, Mark. I don't think Congress will ever do that because whoever is in the majority says, this is going to hurt me. Right? Whoever it is, whether it's a Democrat or a Republican. If you're Democrat, we want to be able to gerrymander our districts. We can do it better than the other guys and overcome their numbers. You know, California is a big state. We got a lot of districts here. We can do this so that the Republicans are really screwed. And meanwhile, in North Dakota and South Dakota, where there's only, where there's two, they're all going to go one way, or maybe. And Virginia's change is purple. It's changing colors. So they got issues. So that's the issue with this case. The court itself does not have the power in saying it shouldn't take this decision. This is a decision to eliminate political considerations from districting must be made by political bodies, not unelected federal judges. That's the decision they made. I'm not sure, I know you disagree with it.
I do.
Some people.
I mean, that's throwing out the race card, the trump card that I think would be a way in, but that's me.
Okay. What about proportional representation? Yes. Oh,
Just a small question. Common cause, is it the group common cause or is it some other thing?
it's the group common cause. They were a party to the case. Okay. The question was in the lower right-hand corner of the case, Ruccio versus Common Cause, is that the common cause that she's familiar with the organization? And the answer is yes. They brought the case to try and get the court to accept the idea that partisan gerrymandering violated equal protection and was unconstitutional. The court applied the political doctrine and said, some people may be getting screwed here, but it's not for judges to make that decision.
If the court says
It's not our job to do that, that's the legislature's job. How come the court decided it was okay to decide that a company, Citizens United, was a human being?
Oh, that's a completely different issue. Corporations, you mean representing corporations or people? I can't answer that question in a short answer. The question is, how does the political question doctrine and what judges, whether judges should use restraint and not have said that corporations should be treated as people for the purpose of the First Amendment, as in the Citizens United case. I'm going to give one quick response to that question. When the issue of corporations and the First Amendment and the Bill of Rights first came up, it was in 1876 or 1879. And it was in response to a law in California that basically denied railroads equal protection of the laws. It basically said that railroad property would be taxed differently than other people's property and other businesses' property. That if you were a railroad, your property was taxed on the full value of the property. But if you were a corporation that owned property, but you weren't in the railroad business, your property would only be taxed on your equity in the property. So that's clearly a denial of equal protection. And the court said for the purpose, and the court, when that case came before the Supreme Court, the court sent a letter to the lawyers saying, don't argue that corporations should be treated differently under the Bill of Rights. Corporations should have the same rights as people when it comes to equal protection. That's where the doctrine came from, back in the 1870s. Another case, another time, I talked about the Citizens United case 5 years ago. Maybe it's time to revisit it. Okay, now I want to talk about proportional representation, which two of you have raised, one last week and once this. Is it, the European system gives every party a number of seats in the legislature in proportion to their support at the polls. Is this a necessary component for a government to be truly Republican, to be Democratic? Robert's majority opinion in this case, which I'll say the name again because I don't always pronounce it right, Rucho versus Common Cause, said no. First, that's not what the framers intended. That's not in the Constitution. Therefore, it's not required. And it's not required in the Constitution itself. Second, federal judges should not make rules neither permitted nor contemplated by the Constitution, nor should judges decide whether constitutional provisions clear on their face are fair enough. That's just too much of a moving target. And that's why the Supreme Court has basically held that proportional representation is not constitutionally required in the United States. Because that's not how our country was set up. We don't do it, the idea is we don't do it that way. And there's some value for saying that. And if you're going to change it, it shouldn't be unelected federal judges who were appointed for life to make that decision. Now, the dissent in the Rucho case was written by Justice Elena Kagan. And let me tell you, she writes beautifully. If you ever want to read something that's so well written, she just writes beautifully. And she begins the dissent with the following sentence. Quote, "For the first time ever, this court refuses to remedy a constitutional violation because it thinks the task beyond judicial capabilities." Close quote. She states that our constitutional system is predicated on popular sovereignty. The people express that sovereignty every election day by freely choosing who shall represent them. But partisan gerrymandering can make it meaningless. The majority's assumption that political issues are too iffy for judges to decide is a false issue. She said that's a red herring. She noted that the district courts that heard the trials in both Maryland and in North Carolina used a two-part test to determine if partisan gerrymandering violated disadvantaged voters' constitutional rights. She, in effect, they invented their own test. The first requirement of the test was, is the intent, does the plaintiff who has the risk, what's called the risk of non-persuasion, whoever's challenging the plan, have they proved that there was an specific intent to discriminate against a particular partisan group by making it more difficult to elect their favorite candidates. That's the first part of the test. The second part of the test, which the plaintiff also must have the risk of non-persuasion on, the plaintiff has to prove or establish that the plan in question substantially dilutes their votes. What's substantial? If both are true, then the plaintiffs have been denied equal protection. They argued that equal protection doesn't require an absence of partisanship in drafting a plan, only that there not be an intent to discriminate and that there is no substantial dilution of the voting weight of political opponents. Well, boy, it's really hard to prove both intent and substantial are both moving targets. Her dissents noticed that mathematical models using computer technology provided clear evidence that a map can produce significant dilution. She says this isn't a problem. When the Supreme Court decides cases, both opinions are circulated among the judges. So the majority and the dissenting opinions have the advantage, have the ability, they know what the other side is saying. And so the majority opinion will always have a section that tries to refute the arguments of the dissent. And the dissent will have sections that refute the arguments of the majority. And the majority opinion rejected Justice Kagan's argument regarding this test. How much dilution does it take to deny equal protection? Must a districting plan try to equalize party preferences? Is that even possible? Would under the test proposed, should judges be called upon to decide how much is too much? The dissent doesn't suggest that the national government, whether acting through Congress or the courts, has the power under the Constitution to tell the states they can't even consider partisan factors. And the dissent doesn't do that. Maybe they should. Maybe there is that Congress, in its power to regulate elections, could instruct the states not to consider districting. Now, they can't tell the state legislatures you have to give it to an independent commission. That because the Constitution specifically states that districting is left to the state legislatures. So it would take a constitutional amendment to change that. Some states have, by state votes, appointed district, commissions to do redistricting. And the provisions in those instructions to those commissions are to ignore partisan issues. California is one of those states. Arizona has done that too. And the Supreme Court has held that states themselves may choose to do so. And a number of states have done so. But how fair is it if some states do it and others don't? If some people are fair and other people are unfair, isn't that screwing the people who are trying to be fair? That's the issue. So, I'm not sure, my side is not, this is not as simple or easy as either side imagines. I think the majority was concerned that if the Supreme Court held that gerrymandering for partisan purposes was not covered by the political question doctrine, every redistricting decision in every case would end up in federal court. And is that good policy? Do we want the federal courts to be inundated with lawsuits over districting, saying that your lines are too wrong? The Democrats don't only get 60%, don't get 50%, even though they haven't gotten 50% of the vote in that state forever. Or, you've only given us 30% because that's how much we got in the last 5 elections, but we're going to change that. We should get more. How do you make those decisions? And should judges be the ones making them? That's, I don't think it's a cut and dry case. And I think there's some truth to the idea that, as my mother used to say, when I say, that's not fair, life's unfair, dude, get used to it. And there's a certain amount to that. Yes, ma'am.
Is there no recourse then for gerrymandering?
If there is recourse from gerrymandering, I think it's up to Congress. What is the possibility that Congress will address this? Slim and none.
There is no recourse then.
Well, there's political recourse. you know, if there was, if every state had a referendum at the same time on this issue, and the vote was 70-30 on a national referendum, do you think Congress might then do something when their phony baloney jobs were at stake? They might. You know, I remember one of my favorite movies is I love Mel Brooks, and they're in Blazing Saddles. This is one decision where government says, "We got to do something, gentlemen. Our phony baloney jobs are at stake." Well, you know, that's if there a possibility, there's a possibility. Okay, I want to spend the rest of my time talking about the Anderson versus South Carolina conference of the NAACP case that was decided last May. The case involves a proposed map that Black voters challenged, basically down in Charleston. And this slide isn't really very helpful. I'd only have it there just so that I got something on the screen that relates to this case I'm going to spend 4 pages talking. Black voters challenged the districting as unconstitutional under Section 2 of the Voting Rights Act, as well as the denied equal protection. The plan was designed to protect Republican candidates in the Charleston district by moving 62% of Democratic voters out of that district into a neighboring district. That was already overwhelmingly Democratic. It just so happened that those 62% of Democratic voters also happen to be Black. South Carolina defended the plan as being entirely motivated by partisan political considerations, relying on the political question doctrine. The plan's drafters also testified that they didn't consider race in any of the voters in deciding who should be in what districts. And after a 9-day trial, the district court found for the challengers, the NAACP. The district court reasoned that because an overwhelmingly large percentage of impacted voters were non-white, meant that race had to have been considered. You're just filling me with bullshit if you say you didn't consider race. The opinion notes that the evidence showed that Black voters in South Carolina virtually always voted Democratic. The opinion states that once a state says that the planners considered only party preferences and racial data was not considered, courts should use, quote, extraordinary caution, close quote, when finding district lines were drawn primarily based on race. And by the way, is it any surprise that this opinion was written by Justice Alito? Why caution, says me? Because invalidating a state legislature's redistricting plan, quote, represents a serious intrusion of the most vital of local functions, close quote. So to untangle, close quote, race from legitimate political considerations, a party challenging the plan has the burden of proof to show that race was the predominating factor in decisions concerning which voters should be in which district. This is something, he's adding something new. He's saying race has to be predominant. All the voting rights says is it has to have a racial effect. The opinion states that once the state asserts that race was not a predominant factor in drafting the plan, the trial court should presume that the state acts in good faith. Further, if the plan is challenged for being predominantly racially motivated, the trial court should presume that the plan is sufficiently narrowed unless the plaintiff presents an alternative plan that produces the same partisan advantages, but without impacting as many Black voters. Before this case, the rule was that if the strict scrutiny case applied, the strict scrutiny test applied, the state had the burden of proving the other way around. He's shifted the risk of non-persuasion from one side to the other to get to the result he wants, the majority wants. So the opinion, so that the state, before the state had the burden to prove that there was not any other way to accomplish the state's interest without considering race. Now the plaintiff has to prove the reverse of that, which is possible, but really expensive, shifting a tremendous financial burden from one side to the other. Yes, sir.
Maybe you confirm this is true or not. I think I heard of the 2 districts impacted, percentage of Black voters stayed virtually the same in both.
No, it didn't.
That's not true.
That's not true. That what I understand is that all the voters that were moved into District 1 to bring its population up to one man, one vote were black.
I heard it's something like 18% in both districts, and
That might be the case, but in a sense, when you're moving voters, if you're only moving voters of one race, the numbers may be the same at the end, but you're still making decisions based on race. You're impacting racial minorities, contrary to what the Voting Rights Act says. That was the theory of the case. So Alito's opinion for the majority held that the district court's factual findings were, quote, clearly erroneous, big surprise, because the trial court did not give those factors that he says they should have given sufficient weight, namely the good faith of and the testimony of the divisions, the proponents of the plan that they didn't consider race. And he says that such failure infects the trial court's findings and renders them clearly erroneous. Alito's opinion is 35 pages long. It's really hard to follow. Thomas, in 29 pages, argues that because the Constitution allocates districting to the states, state control is absolute and is not subject to 14th Amendment-based limitations. Period. He takes 29 pages to do this. He indicates that he would have voted with the dissents in both Baker versus Carr and Reynolds versus Sims. He doesn't even believe in one man, one vote. Now, Justice Kagan's dissent is equally long as the opinion. It's 35 pages because she has to review the evidence also in great detail. Her argument is that the district court's findings were supported by ample evidence and were not clearly erroneous. She notes the district court found that South Carolina's position that it relied on voting as opposed to racial demographics was less credible, less worthy of belief. And the district court's findings of fact concluded that the plan's drafters included both partisan and racial data to advance partisan goals to make certain districts more safely Republican. Just because it's plausible that the Supreme Court didn't predominantly rely on race doesn't mean that in fact, it doesn't mean in fact that the Supreme Court's assertion South Carolina didn't rely on race, must control the result. In other words, just because you say it's so doesn't mean it's so. That's her opinion. She says the majority ignores a cardinal rule. There's a cardinal rule for reviewing courts that when it comes to finding of facts after a trial, you don't overturn the findings of the lower court unless they are, quote, clearly erroneous. Clearly erroneous means there is no credible evidence to support them. Not that you think certain evidence is more worthy of belief than other evidence. That's not the decision for the reviewing court to make. That's a decision the trial court should make. And she accuses the majority of ignoring that. And she's absolutely right. She says an appellate court like the Supreme Court is obligated to accept the trial court's factual determinations that are supported by ample evidence. And the majority simply defers to the assertions of the state, South Carolina, the losing side as to who to believe in order to reach their desired result. That's what she says about the case. And I think she's absolutely right. The critical issue, she says, isn't whether the plan's motivation was primarily to advance political goals. That's not the right question to ask. The question to ask is the plan advancing political goals by racial means? Mm-hmm. And because all the voters that moved happen to be Black, she's arguing that clearly that's what they've done. And she says if you're going to presume that the answer is no, just because the plan's proponents say it's no, you're really saying no plaintiff can ever win unless the state admits we relied on race and that was our primary goal. And what do you think the probability of that happening? Okay. My take is the majority simply wants to deter liberal plaintiffs challenging state partisan redistricting plans for violating the Voting Rights Amendment. That's what they're trying to do. Roberts, Alito, and the usual suspects are just fine where white voters claim that they are denied equal protection when they're facing predominantly Black voters. But their hatchet job on section 2 logically follows their earlier decision that preclearance was unconstitutional. I think it's obvious from this and previous decisions that the majority believes that the 1965 Voting Rights Act isn't needed now, and it probably wasn't needed then. These are reactionary decisions, I believe. These are reactionary decisions by activist judges who don't believe the Voting Rights Act is needed, or less charitably, don't care.
Was it 5-4 or 6-3?
6-3, there it went with the majority. Is there a partial cure? There's a partial cure. In 2021, the House passed the John R. Lewis Voting Rights Act, but it couldn't get the 60 votes it needed to bring it to the floor in the Senate, according to the Senate rules. It would have reinstituted plea clearance with new findings of fact to support it. It would have strengthened section 2 of the Voting Rights Act. It would have outlawed a number of practices that make it more difficult for people to vote. But it did not address the partisan gerrymandering issue. And I have mixed views. I'll be candid with you. I have mixed views on political question doctrine. On one hand, I agree with you because I wrote in Eldridge Cleaver in 1968. My views are not a secret, my political views. But on the other hand, I also think that there's a place for judicial restraint. I do believe in democracy, and I think that unelected federal judges who serve for life should sometimes think long and hard about what the fuck they're doing. Applied to gerrymandering, I think it helps Republicans in North Carolina, and it helped Democrats in Maryland. And I think there's something to be said for the notion that judicial restraint and to place some trust in our more democratically responsive branches of government. Just not where equal protection and due process are involved. So there we have it. I have sincere hopes for this election. And I would suggest that certain justices who I will remain nameless should not exercise, eat the wrong foods, start smoking, gain lots of weight, and be consumed with stress. And on that note, any more questions? Okay, thank you all. Next time, the election will know, and we will talk about homelessness and the Grants Pass case.